Dictation will start after 5 seconds. Start. Purpose for existence of the institutions of court, and as such the court should liberally construe the said words sufficient cause appearing in section 5 of the Limitation Act. Stop. In support of such contention, he cited the decisions of the Supreme Court in cases of collector land acquisition Anantnag versus Minister Katiji, reported in AIR 1987 SC 1353, N. Balakrishnan versus M. Krishnamurthy, reported in 1999 1 Cal LT SC 51, M. K. Prasad versus P. Arumugam, reported in 2001 6 SCC 176, and Basraj versus Special Land Acquisition Officer, reported in AIR 2014 SC 746. Stop. He further contended that while dealing with an application for setting aside abatement, the court should also adopt a liberal approach. Stop. In support of such submission, he relied on the decisions of the Supreme Court in the cases of Nithailal and ANR versus Annabai and ORS, reported in 2003 10 SCC 691, Ganesh Prasad versus Sanjeev Prasad, reported in 2004 7 SCC 482. Stop. The sum and substance of the contention of Mr. Raichaudhuri is that since the respondent number 1 did not inform the appellant of the death of the respondent numbers 2 to 5 in terms of mandatory provisions in order XXII Rule 10A of the court, and the respondent number 1 for the first time informed the death of said respondents in March 2013, and the names of the respective legal representatives of the deceased respondents by the said letter dated May 3rd, 2013, and as such the appellant has established sufficient cause under subrule 5 of Rule 4 of Order XXII of the court for obtaining setting aside of the abatement of the appeal as against the deceased respondent numbers 2 to 5. Para. However, Mr. Bhaskar Ghosh, learned senior counsel appearing for the respondent number 1, and opposing the application of the appellant raised various contentions for dismissal of the appellant's application for setting aside the abatement of the appeal. Stop. He first contended that the provisions of Rule 10A of Order XXII of the court is not mandatory, and in any event the said provision cannot be made applicable in this case. Stop. According to him, Rule 10A of Order XXII provides that it is the duty of the advocate to inform the court of the death of the party whom he was representing when he comes to know such death. Stop. Thus, according to him, when Mrs. Devarati Sen Bose, advocate is all along representing the respondent number 1 alone, she had no obligation under Rule 10A of Order XXII of the court. Stop. He further submitted that in any event, the provisions in Rule 10A of Order XXII of the court is not mandatory, and the provision does not take away the duty on the part of the plaintiff or the appellant, as the case may be, to file application for substitution of the legal heirs of the deceased defendant or respondent within the prescribed period after making necessary inquiries with regard to the particulars of the legal representatives of the deceased defendant or respondent. Stop. In support of such contention, Mr. Ghosh relied on the decision of the division bench of the Andhra Pradesh High Court in case of Gurjala Bharati ANR versus Vindhya Corporation ORS, reported in AIR 2007 AP 325, and decision of the Supreme Court in the case of Katari Surya Narayana and ORS versus Kopisetti Subba Rao and ORS, reported in 2009 11 SCC 183. Stop. Para. relying on the decisions of the Supreme Court in the case of Ramlal versus Rewa Coalfields Limited, reported in AIR 1962 SC 361, and the decision cited by Stop.